5 seconds to go. Start. Thus, from the aforesaid, it appears that the order of preventive detention came to be passed essentially on the ground that in the past two first information reports were registered against the appellant herein for the offences punishable under sections 22B, 22C, 29 and 21B of the Narcotic Drugs and Psychotropic Substances Act 1985 and is a habitual offender. The first FIR is dated 5th November 2019 and the second FIR is dated 25th April 2021. At the end of the investigation of the FIR dated 5th November 2019, the charge sheet came to be filed and the trial is pending as on date. The investigation so far as the FIR dated 25th April 2021 is concerned, the same is shown to have been pending on the date of the proposal. However, what is important to note is that in both the aforesaid cases registered under the NDPS Act 1985, the appellant herein was ordered to be released on bail by the Special Court Tripura. The appellant questioned the legality and validity of the detention order by filing the writ petition civil number 6 of 2021 in the High Court of Tripura at Agartala. The High Court void the impugned judgment and order dated 1st June 2022 rejected the writ application, thereby affirming the order of preventive detention. In such circumstances referred to above, the appellant detainee is before this court with the present appeal. We have heard Miss Madhumita Bhattacharjee, the learned counsel appearing for the appellant detainee, and Mr. Nachiketa Joshi, the learned counsel appearing for the state of Tripura. Manifold contentions have been raised by the learned counsel appearing on both the sides. We are persuaded to allow this appeal on the following two grounds: delay in passing the order of detention from the date of proposal, thereby snapping the live and proximate link between the prejudicial activities and the purpose of detention, and failure on the part of the detaining authority in explaining such delay in any manner. The detaining authority remained oblivious of the fact that in both the criminal cases relied upon by the detaining authority for the purpose of passing the order of detention, the appellant detainee was ordered to be released on bail by the special court. The detaining authority remained oblivious as this matter and vital fact of the appellant detainee being released on bail in both the cases was suppressed, or rather not brought to the notice of the detaining authority by the sponsoring authority at the time of forwarding the proposals to pass the appropriate order of preventive detention. We may recapitulate the necessary facts which have a bearing so far as the issue of delay is concerned. The proposal to take steps to preventively detain the appellant at the end of the Superintendent of Police addressed to the Superintendent of Police West Tripura, Agartala is dated 28th of June 2021. The proposal in turn forwarded by the Assistant Inspector General of Police on behalf of the Director General to the Secretary, Home Department is dated 14th July 2021. Stop.